Welcome back to Real Estate School. You know, we get a lot of great comments from our viewers, and one recently asked about interest in real estate. The viewer told us that they hear that term a lot on different videos, but never really get a good explanation of what an interest is. So let's clear that up today. An interest, simply put, is ownership of any one of the bundle of rights. You remember the bundle of rights. Bundle of rights is part of ownership of real property. Real property, if you recall, is land, all man-made items permanently attached to the land, and the legal rights that go along with ownership of the land. That's real property. The ownership rights are called a bundle of legal rights. And ownership of any one of those, or any combination of those, would be an interest in land. You might recall the acronym we gave you for a bundle of rights, UPT. Use, possession, transfer, encumber, or exclude. Now, under interest, there are various ways to have interest in land. The main two types that we need to discuss for your real estate exam purposes are possessory and non-possessory interest. There are others, for example, public interest in land. But for your test, we'll stick with these two. Now, possessory interest that allows possession of the land, either now or sometime in the future, that's referred to as an estate in land. An estate in land is an interest that allows possession or holding of the land, either now or sometime in the future. Or non-possessory interest. These are called encumbrances. This is a broad term. My definition, something that attaches to the land. It reduces the value or impairs the use, but it doesn't prevent transferability. That's an encumbrance. And there's several things that fall under that category of encumbrances that we'll discuss. But I want to start with estates in land. The main two types of estates are freehold, which we recognize as ownership estates in land. And if it's not freehold, if it's less than freehold, it is leasehold estates. Now, freehold estates, ownership. Under freehold, we have different types. And here's a term that you'll actually take and use in the real estate business. Very little of these terms you actually use in the real estate business, but you can ask any real estate agent what is the highest form of ownership recognized by law, and they will all tell you fee simple absolute ownership. What we recognize as the highest ownership in land. Now, before we go further, let's make that point clear. No ownership is absolute. If you own land, you have to pay the government taxes on that land, or they're going to take it from you. If you own land, you have to follow the zoning laws. The county or the city tells you what you can use your land for. And if you own land in a homeowners association, you have to follow the rules of the homeowners association. But fee simple absolute, it's as close as it gets to complete ownership. As opposed to fee simple absolute, fee simple defeasible. What does that sound like? Ownership that can be defeated. Ownership that comes to you on a condition. You own the land, but if you can't use it for this. If you use the land for this, me or my heirs can regain ownership of the land. The key to creating this defeasible estate is the terminology written into the deed, into the granting clause of the deed, which would normally read, I, whatever my name is, grant you all of my interest you have in this property for the rest of your life. If I left the language alone at that, I'm granting you fee simple absolute ownership. If I add to that granting clause words like so long as, or while or during, you have complete ownership of this land for the rest of your life, so long as you don't use it for this. This stuff sounds complicated, but in reality it's not that difficult. It's basically language written into the granting clause of the deed that dictates what type of ownership I'm conveying to you. In this case, a defeasible fee estate. Another type of freehold estate would be a life estate. Simply, this is ownership given based on somebody's lifetime. Again, the language written in the granting clause. I grant you all of my interest you have in this land for the duration of your life, or it could be for the life of another person you own this land. When that measuring life ends, ownership would either revert back to the creator of the life estate, or maybe the life estate creator has decided they're not going to be here, so they've named a party to receive ownership. They're called the remainderman. And I think for test purposes, that's as far as we need to get into estates in land. Well, without being a freehold estate, it would be less than freehold or leasehold. If the duration of possession can be measured in time, normally it's a leasehold estate. If it's your property, but just for the next 5 years you don't own that property, you're renting that property. Well, under the category of leasehold estates, there's 4 types of estates to be aware of, starting with an estate for years. This lease would be more common with commercial. This is a lease that has a definite start date and a definite end date. The lease does not require any type of notice to terminate. When the date comes, the lease expires. If the tenant wants to stay in possession, we're going to have to negotiate a new lease. The next type of leasehold estate would be a periodic tenancy or an estate from period to period. This lease is specifically dated to start this date and to end that date. However, to end on that date, either the landlord or the tenant would have to give notice, whatever notice the lease calls for. Without that notice, the lease renews for the same terms and conditions. As long as the tenant pays rent and the landlord accepts rent, the lease continues. That's an estate from period to period. The third type of leasehold estate would be an estate at will. This is an open-ended tenancy. This lease has a start date, but it does not have any expiration date. It's open-ended. An example would be the landlord tells the tenant, I have a relative moving to town later in the year. You can stay in the apartment till then. When a relative arrives, the lease would end. So we have a lease with a start date, but we don't have any type of ending date. The unique feature of an estate for will and what you'd be tested on, this is the only one of these tenancies that would be terminated with the death of the landlord or the tenant. The fourth type of leasehold estate, an estate at sufferance. This estate arises when a tenant with an estate for years remains in possession or holds over after the lease expires. The expiration date comes up, the tenant says, I have nowhere to go, I'm staying here. We have an estate at sufferance. Now let's focus on non-possessory interest or encumbrances. As I said, many types of encumbrances exist, either monetary or non-monetary. Liens, a lien on a property is unique. It's a monetary interest in land based on money owed. Whenever you borrow money and pledge your property as security for that money borrowed, the lender goes down to the city or county and records a lien against the property. Other types of liens are physical in nature, such as easements or encroachments. Somebody has the right to cross your property to get to their property. Your property is the servient, and they are the dominant tenement. The easement is an encumbrance on the servient tenement. This limiting the use of the property might even be reducing the value of your property, but it doesn't prevent you from selling that property. An easement. Or an encroachment. Your neighbor puts up a shed. By mistake, they cross over 3 foot onto your property. Your neighbor's encroaching onto your land with their shed. Usually this would be identified by a spot survey done before a real estate closing. The encroachment is limiting the use of your property, but it doesn't prevent you from transferring ownership. This is an encumbrance, a non-possessory interest in land. Another form of encumbrance would be a deed restriction. Language written into the deed that limits the use of the property. The most common deed restrictions that we're familiar with would be the rules of the homeowners association. These simply aren't just a list of rules written down on a sheet of paper. They're rules incorporated into the deed, either written into the deed or referenced, recorded down at the city or county and referenced in the deed. So those homeowners that say, I don't have to follow the rules in this neighborhood, nobody told me about the rules. Well, yes, you did. When you accepted the deed to the property, you accepted the rules of the homeowners association. They are restrictions on the use of the property incorporated into the deed. Or it could be a private restriction. Another private restriction, a grandfather was hoping to pass the family farm down to his grandson, but now grandfather's faced with the unfortunate fact that he's going to sell the family farm to pay the bills. Well, one thing grandfather's going to ensure is the family farm remains a farm forever. So grandfather wrote that language in the deed. Whoever owns this land in the future can only use it for farming purposes. Don't you think that affects the value of ownership of that land? But it doesn't prevent transferability. This is an encumbrance on the land. Whoever owns that land 500 years down the road can only use it for farming purposes because grandfather wrote that into the deed way back when. Things like maybe eminent domain. If the city or county wanted that land to build a high school, they could take it and change the use. But from seller to buyer, you can't change a deed restriction. Well, I certainly hope that cleared up that topic regarding interest in land. Please subscribe, ring that bell, and we'll let you know as we release our next video. Thank you.